fact that teachers may have some remedy with those contracts. It was brought up it's in the defendant's papers in their response to our motion for injunctive relief on damages. It basically just lays out what the contractual remedy is in those collective bargaining agreements.
Well, then, Your Honor,
Mr. Wells, can I respond for a second?
I'm sorry, I didn't realize we were going to have a tag team. Go ahead.
No, that's okay. Hi, Your Honor. I've been the counsel to these unions for over 40 years, and the collective bargaining agreement arbitration and grievance mechanism does not cover constitutional questions, and we just wanted to make sure that was clear in the record. Not a single one of our CBA arbitration mechanisms cover this.
Your Honor, I think that's a legal argument, and I have no problem with them making that in their proposed findings. What I objected to was the coming in on a rebuttal to deal with an argument that number one's been in the papers, and number two, I cross-examined their president on. So we still object. They can make their argument.
I'll allow the declaration.
The second one deals with a rebuttal declaration from Dr. Nielsen, who testified live, and it basically constitute a reprise of her opinions and anecdotes about why she believes it's not safe to open. It isn't a proper rebuttal affidavit. It's just more of the same experts. So we don't believe that that's an appropriate use of a rebuttal declaration, particularly with an expert who we won't be cross-examining on those points.
Her declaration is responding to their expert's testimony regarding the fact that children don't spread it to adults. So specific to that point.
I'm going to sustain the objection to Dr. Nielsen's declaration. I think she testified at length about her opinion, so I'm going to sustain that objection.
Okay. And I just wanted to confirm on our exhibits, the last one we had was 63, correct? Judge, on your list?
Plaintiff 63 was admitted, right?
Yes, well, I think so. I just wanted to confirm. And then just two more things. Dr. Nielsen referred to the ACA data, which is the Agency for Healthcare Administration, the daily numbers on that. I think we maybe referenced it, but it hadn't been moved into evidence. So I wanted to make that Plaintiff 64.
I think you have it already, but we don't object. It's live link anyway.
Okay.
So you think it's already in?
I thought it was, Your Honor, but no reason holding up the proceedings if counsel just wants an abundance of caution to make sure she's got everything she needs in.
So I'll admit Plaintiff 64, the ACA.
Okay, thank you.
Documents.
Okay, and we also wanted to include the Mass General, the new article we had Dr. Bonanchara review during lunch.
Is that the preprint or the?
Yeah, the preprint.
That he was cross-examined on? We don't have any objection to it being going in.
Okay, so that'll be Plaintiff 65.
Plaintiff 65 is admitted.
Okay, that's it. And then we'll have the two declarations, the Manatee County parent and Andrew Spar, the FEA representative.
Correct.
Okay, that's it. Thank you.
Y'all ready for closing arguments?
Your Honor, we are prepared to go forward with closing arguments, and the plaintiffs have agreed that Mr. Stewart will go initially, Mr. Coffey on behalf of the FEA plaintiffs, Mr. Wells will respond, and then we would like to save about 20 minutes for rebuttal as the court would permit.
And again, I would like for y'all to keep the closing arguments to an hour. If you do feel like you need to go longer, I certainly understand that. But I will give the plaintiffs a heads up after about 40 minutes so that you got about 20 or so left.
Your Honor, that'd be perfect. Thank you.
Okay.
That's a long rebuttal, Your Honor, but I understand your ruling. And on our argument, the way we intend to handle it is I'm going to split that with my partner, Mr. Hill. I'll speak generally to the to the facts, and he will speak to the law, and hopefully there won't be too much overlap, but we'll use our hour that way.
All right. Okay, Mr. Stewart.
Actually, Your Honor, Billy Whelan for the plaintiffs. I'm going to go ahead and deliver the closing for our case, if you will, if I may proceed.
Mr. Whelan, you may proceed.
Thank you, Your Honor. And again, Your Honor, I want to say that we appreciate you working us in so quickly on this matter and allowing us to present our case over the past 2 days. Your Honor, you've heard about 18 hours of testimony from witnesses and experts. But at the end of the day, we have one simple question. And that question is, if we send children and teachers back into the classroom for live face-to-face instruction, are they going to be safe and secure? My colleague, Mr. Stewart, and I brought you to this question on behalf of our clients because we believe that you are in the best position to prevent avoidable death. Your Honor, the defense likes to argue about constitutional encroachment in this case, but the founding fathers of this nation and our state made clear that we have 3 separate but co-equal branches of government, ensuring checks and balances on each. Now, while our case may share some very similar legal issues with our cohorts at the Florida Education Association, our case is a grassroots case that came up from one mother and one teacher who were both concerned about what was happening with our schools. Since then, we've grown to include 2 other teachers who are being forced back into the classroom against their will. Your Honor, again, the heart of this case is safety and security, and that's guaranteed by the Florida Constitution and the Florida legislature.
Let me ask you, Mr. Whelan, on your case specifically, what are you going to be asking me to do?
Sure, Your Honor, we're asking you to enjoin the defendants from opening brick and mortar schools for live face-to-face instruction based on an arbitrary and capricious emergency order issued by the defendants in this case. And that emergency order would be Emergency Order 6, because we believe, Your Honor, that violates Article 9, Section 1A of the Florida Constitution, as well as Florida Statute 1006.07, subsection 6.
So you're asking me to rule that all of Emergency Order 6 is unconstitutional because it's arbitrary and capricious?
In violation of the Florida Constitution, yes, Your Honor.
And what happens if I do that?
Well, I think, Your Honor, what my closing argument will make clear is that would return the power to the local school boards to make the decision about when it's safe and secure to open those schools.
Okay, you may proceed.
Thank you, Your Honor. Again, going back, Your Honor, we believe that the safety and security question needs to be answered by those 67 local school boards. Those local school boards that can set up medical advisory panels, that can set up experts, that can bring them in and give testimony about when it is safe and secure to open these schools. The problem is Emergency Order 6 has taken away the power from the local school boards. And you heard that testimony about Hillsborough County. The gravity of this decision isn't lost on us, Your Honor. As we celebrated the new year on January 1st and made our resolutions, no one could have imagined what we were going to face starting in March. Lockdowns across Florida, Florida becoming the global epicenter of a highly contagious virus. Florida having 600,000 positive cases. And ironically, yesterday, while the defendant's expert from California testified, Florida surpassed 10,000 deaths. 6 days after the emergency order was entered, Your Honor, we had the worst day of positive cases in Florida, 15,300. And it's undisputed, and there's been no testimony from defense or anyone else that any one county in Florida is under a 5% positivity rate. The defense provided you with at least 8 hours of testimony, but what's important, Your Honor, is what you didn't hear. You did not hear from the defense that they brought any medical doctors who are in the front lines in before they put forward this emergency order and decided to issue the emergency order. You didn't hear from their own local school board member who they called as a witness, who's an epidemiologist. You didn't hear from him that he was involved in the decision to put forward this emergency order. And you didn't hear from any witnesses about any medical advisory boards or any other experts that were called in before this emergency order was entered. What we did, Your Honor, is provided you with medical evidence. We brought 2 doctors. We brought Dr. Burke and Dr. Nielsen to you to provide you with an understanding of what's going on with COVID, both of which said 5% positivity is generally accepted among the community as a first step to making sure that we're safe to return students and teachers to schools. And that's backed by scientific data and publications. As much as the defense's star witness wants to ignore the WHO or the CDC, or the American Academy of Pediatrics, the doctors on the front lines are the ones who have decided and have written letters to the governor and other officials in the state to say, we need to wait until we're at a 5% positivity rate before we start opening schools. Judge, you heard from Dr. Nielsen about patients she's treated. Patients who have suffered the effects of COVID. Patients that have long-term and lasting effects due to COVID infections. You've heard that she even had a transmission or an outbreak, as she described it, in her own office with her own staff who's been trained on how to be safe when people come in with COVID. You heard that transmission, according to Dr. Nielsen, happens between a parent and a child and a parent. And that's supported by the Georgia study that my cohort, Mr. Stewart, brought into evidence through cross-examination yesterday. It's also
of course, Dr. Bhattacharya says that's not right.
I agree that was his testimony, Your Honor, but I also agree that the Massachusetts study that we just entered into evidence, which came out very, very recently and is being circulated in the media and was even mentioned by Dr. Fauci yesterday, specifically throws out his opinion. And not to mention the fact, Your Honor, that I went back and watched the testimony, the cross-examination of Dr. Bhattacharya yesterday. And Dr. Bhattacharya says that the science essentially is not settled. It's being debated in the medical community. Did I answer your question, Your Honor?
Sure, yes, sir.
Thank you, Your Honor. May I continue?
Sure.
Thank you. And as you mentioned, Your Honor, there was a study brought forward by Dr. Bhattacharya, which was in direct contradiction of the Georgia and Massachusetts study, but it was performed before those studies. He also brought forward a controversial study that he put forward and published, but who admitted on cross-examination they may have recruited some of their participants incorrectly, as that information was accidentally released by his wife, that a donation was obtained after those results were entered. You then heard, Your Honor, not only from Dr. Nielsen, but Dr. Burke, whose credentials speak for themselves. Dr. Burke is a doctor at Mass General and teaches at Harvard. And his testimony was straightforward, laying out a roadmap of when it would be safe to open schools in Florida. He said we need to have three things, Your Honor. We need to have a plan, we need to have green light conditions, and we need to have mitigation tactics. All we've gotten from the Department of Education is an arbitrary date on when we need to send kids back to school. There is no plan. We don't have those green light conditions, which were 5% positivity. And the mitigation tactics haven't been mentioned. That includes training, proper contact tracing, proper ventilation, air filters, cleaning, masks, sanitizing, and social distancing. At the end of Dr. Burke's testimony, we asked him a very important question. Is Florida, in his estimation, ready, and his estimation and his expertise, are they ready to open schools? And his answer was no. Mr. Stewart asked him that question directly, and I believe Mr. Stewart even asked him if we'd be ready by August 31st, 10 days from today. And I believe his answer was the same, that we would not be ready because we haven't gone through those three important steps: a proper plan, the green light conditions, and mitigation tactics. You did hear from Dr. Bhattacharya, as you mentioned, who is a research expert from California, has never treated a patient in his life. And it was never, and I think this is important, Your Honor, especially based on your question, Dr. Bhattacharya was never contacted by the state of Florida Department of Education until after this case started. He wasn't involved in the planning of the emergency order. He was simply asked to provide expert testimony about his research into COVID-19. But his research was limited, Your Honor. If you'll remember, his research was into death of COVID-19, not the long-term and lasting effects. His job, he testified, is to balance when it's safe to open things like schools or businesses and balance that with the loss of life. And we would submit, Your Honor, this is an avoidable loss of life. And we're not looking to create a balance where we decide how many people how many people we should sacrifice and still open schools. Now, there's some things that Dr. Bhattacharya did say that we agree with. And I think a lot of people agreed with, not only on the defense side, but on the plaintiff side as well. And that's that this virus is highly contagious and that it can be transmitted from an adult to an adult to child, and a child to child. Dr. Bhattacharya admitted that. What we disagreed about, as you brought to light, Your Honor, is that whether a child or a teacher can transmit this to an adult or vice versa. But careful review of the defense expert's testimony, as I said before, shows on cross-examination this is being debated in the scientific community. And I would say, Your Honor, based on the recent study, that it may have been answered, that they can transmit it, a child can transmit it to a teacher. Now, what Dr. Bhattacharya didn't say is, as I mentioned before, is despite his 5 months, as he said, of nonstop research into COVID-19, he didn't testify about the long-term or short-term effects of getting COVID-19 if you're lucky to survive. And the most striking thing that Dr. Bhattacharya said, and I remember him testifying to this actually on direct examination, was that Dr. Bhattacharya said that local decision-making is important in responding to COVID-19. And I think that's exactly what this case is about. But the problem is Emergency Order 6 has taken that local decision-making away from the school boards. You heard from Tamara Schamberger in Hillsborough County, who said, and I'll steal a word from Jacob Oliva's testimony yesterday, who said that they tried to put forward what I'd call a dimmer switch approach, where they tried to bring back the most at-risk students by August 24th. And then they do a rolling return with everybody returning by September 14th was their plan. A mere 14 days after this arbitrary August 31st deadline. That was rejected by the Department of Education. A dimmer switch approach, as Jacob Oliva testified should be implemented, was rejected by the state of Florida. Tamara Schamberger testified that to come up with this plan, Your Honor, they actually brought in local medical experts. They formed a medical advisory committee, and every one of those medical advisory committee board members, as you saw on video, except for one, they all said that schools were not safe to open. The only one that did not give an opinion, didn't vote that they were safe to open, but just simply didn't give an opinion, was a representative from the Department of Health. And as you saw from the other video that was put into evidence, the Department of Health has been told that they are not to give an opinion on whether it's safe to open schools. The same Department of Health that's here to protect the citizens of Florida. They're missing in action, Your Honor. Your Honor, you also heard from...
How do you interpret the language, Mr. Whelan, in the executive order on page 2 that says, absent these directives, the day-to-day decision to open or close a school must always rest locally with the board or executive most closely associated with a school?
Your Honor, I believe that's what the executive order says, but in implementation, as we saw from Hillsborough County, that's not what's happening. I mean, they developed, as we said, the medical advisory board, and they asked their local experts whether they're safe to open. And when they put forward a plan, it was rejected. I think that's the problem that we have, Your Honor, is it's one thing to say something and it's another thing to do something. And what's clearly been done here is, even though they say that there should be local input and local control, that's not happening. And they've essentially held hostage the local school boards to ensure that they open by August 31st.
Well, are you saying then that the Emergency Order 6 is not arbitrary and capricious as written, but it's arbitrary and capricious as applied?
Your Honor, I believe that it's arbitrary and capricious as written because it does give a deadline without any, and there was no testimony of any evidence that they put forward that August 31st should be the day that we open schools. Does that answer your question, Your Honor?
I think so, yes.
Thank you, Your Honor. May I continue?
Sure.
Your Honor, as I said, the Department of Health is missing in action. And then we heard from board member Hopes. And not all of us, Your Honor, can be very good friends with Commissioner Corcoran. But his testimony, I think, helps illustrate the problem that we have here, or the argument that we're making, is that this should be a local decision. Commissioner Hopes, board member Hopes, believes that Manatee County is ready to open schools, and we'd submit, based upon the declaration that we put into evidence today, that we would disagree with that assessment from a parent who's on the ground there. But notwithstanding, board member Hopes feels that Manatee County is ready to open schools, and that may be despite the fact that there's been 3 separate school outbreaks in his county. But if you contrast that with Martin County, who 3 days ago reported 292 students with COVID-19 or being quarantined due to COVID-19 and 14 teachers also being quarantined, they're not ready to open. And I think that illustrates why it should be a local control decision. Not every school board has an epidemiologist who studied disease on their panel. And this is, again, illustrates, Your Honor, this should be a local decision. Your Honor, then you heard from Mr. Liz and Mr. Escobar. That's what this case is about. Mr. Liz is one of our plaintiffs. He's a high school teacher here in Orange County. Mr. Escobar is a high school teacher down in Osceola County. Mr. Liz lives with his elderly mother and is being forced into a decision. He testified about the appalling lack of preparedness at his school. He testified that he's in a portable with limited ventilation. He testified that his portable is a pod, if you will, of 40 portables with one bathroom and one working sink with no paper towels. The school is not prepared to open. Mr. Escobar then testified that he's a quadriplegic. His doctors told him that if he comes down with COVID, he's likely to die. He's been told by his school that in the 5 minutes in between classes, he's expected to clean every single desk in that class. He has not been provided the proper PPE to do this, as he testified that he'd only been provided a mask and Kleenex tissues when we asked him that on direct examination. Your Honor, I think this again illustrates how woefully unprepared we are to open schools. And Dr. Nielsen and Dr. Burke's testimony brings that back to light about having a plan, proper green light conditions, and proper mitigation tactics. Your Honor, both of these teachers put in for accommodations. Mr. Escobar, who's a quadriplegic, and Mr. Liz, who lives with his elderly mother, who had set up a plan for his life where his elderly mother-in-law would come in and assist he and his wife with their family. They're being told, they requested the accommodations and were told, no, you need to return to the classroom. Now, this is despite the video clips that you saw of Governor DeSantis and Commissioner Corcoran that says, you know what? All teachers should have a choice on whether or not they should return to schools. If they don't feel safe, they shouldn't have to return to schools. Your Honor, as I said before, it's one thing to say something and another thing to do something. In reality, they haven't been given a choice. They're being forced back into the classrooms. Or if you consider the choice being that they have to give up their entire livelihood, what they went to school for, what they worked for retirement benefits, what their passion is. I guess if you want to say they have a choice that they need to give all of that up and quit their job, or they need to return to the classroom and put their lives at risk. I guess that would be the choice that Governor DeSantis wants us to make, or teachers to make. You heard from Mr. Ingram, who said that this is a common occurrence that's happening around the state for teachers that are being asked or that are requesting accommodations and not being given those accommodations. He also testified about the appalling lack of PPE that's happening. Your Honor, what's made us question a lot of what's going on is the unwillingness of the Department of Education to simply modify the executive order. They're saying that we're asking you to upend the decision of families around the state, which is not lost on us, Your Honor. But just like the pandemic is not the fault of the defendants, this is not the plaintiff's fault. Rather, the fault of the Department of Education in the state of Florida, who created this problem through Executive Order 6 and put forward some arbitrary deadline to return teachers and students to school. Mr. Stewart and I speak for our clients and their families, along with students, parents, and teachers, and staff who don't understand why a bureaucrat in Tallahassee is dictating what happens in Orange County or the other 66 counties around the state, why the power has been taken away by the local school boards, why those same local school boards who are duly elected to make these hard choices, who are elected to put forward medical advisory boards, to rely on experts in the community, why they are being handcuffed by the Department of Education and the governor's office. Now, despite what the Department of Education witness Mr. Oliva had to say about a dimmer switch approach, that's not happening, Your Honor. What's happening is schools are being required to open by August 31st or being threatened with funding issues. Your Honor, and I'm getting close to wrapping up, and I appreciate your indulgence. I think that a lot of us are suffering from COVID fatigue. I know I am. We're social creatures. I'd love to be presenting this case to you, and I'm sure you'd love for us to be in the courtroom and make things a lot easier than what we've gone through. We'd love to be eating out at restaurants or going to concerts, going to weddings, or going to religious services or social gatherings. I'd love not to put a mask on when I run into Publix to grab cheese that we may have forgotten on our grocery list. I'd love to go and see my grandmother in a nursing home with my 2 children. I'd love to have dropped my daughter off in kindergarten, who was supposed to start this year, but instead we're on the computer. I would have loved to share that moment with my wife. But what we're doing is we're being asked to make sacrifices. We've been making these sacrifices for 5 months. We've been making these sacrifices for the betterment of our fellow citizens. And what the emergency order that's been put forward by the Department of Education asks us to do is to unravel all those sacrifices we've made, to throw open the doors of our brick and mortar schools for live face-to-face instruction, forcing teachers into the classroom against their will, despite their underlying conditions or their concerns about their health or their family's health. Now, the defense may want to argue that we just want to keep schools closed, which is not true. The defense has argued that we're asking you to decide each and every one of the counties and when they should open for live face-to-face instruction, which is, again, not true. As I said before, Your Honor, what we're asking you to do is simply rule that this emergency order that was entered is unconstitutional and in violation of the law. This would restore the power to the local school boards. And it would return that local decision-making that not only our witnesses talked about, Your Honor, but their witnesses also discussed local decision-making is important in response to COVID-19. The power to do this is not only found in the Constitution and the law of Florida, but it's also found in the oath of office to protect and defend the Constitution. And there's no dispute that the role of the judicial branch of government is to apply the law and Constitution to executive action. I was given some good advice by my father-in-law years ago, Your Honor, and that's we need to look at big decisions, life-altering decisions, and we need to say in 5 years from now, how are we going to look back on the decision we made? So when we look back 5 years from now on this decision we're faced with, are we going to look back with pride and say how we resumed face-to-face learning in Florida when we rushed 60 plus districts back to in-person learning before they had solid plans in place, how they're not ready to handle a deadly pandemic, but at least we complied with an August 31st arbitrary deadline? Or on the other hand, Your Honor, are we going to say 5 years from now, yes, in 2020, we had to create some inconvenience for some people. We had to delay the school year a few days or a few weeks or a few months while we waited to figure out how to grapple with a crisis that we're all still learning about. Did we make prudent decisions based on science and data, and that we didn't order people back to school based on an arbitrary deadline? That's the question that we're asking. We'd love to get back to normal, but what is getting back to normal in the short term going to cost us in the long term? How many students, teachers, and staff will have lifelong medical issues because of COVID, caught at schools that were open too early without a plan or green light conditions, a school that wasn't prepared? How many of those people will be gone forever? Your Honor, it's a simple question at the end of the day. Are children and teachers going to be safe and secure if we throw open the doors to our schools for live face-to-face instruction before we are ready, because Governor DeSantis and Commissioner Corcoran decided back in July that Florida schools would be ready by August 31st? The plaintiffs would submit to you that we're not.
Mr. Coffey.
Thank you, Your Honor. And Your Honor, I'll try to respond to some of the court's questions at the outset, and then of course talk about some of our views of the evidence and the law. But we start out today as we started out just a few days ago, recognizing that this is a terrifying crisis and it's far from over. The rates of COVID infection, at times it seems like maybe they've stabilized, but by any metric, and of course we're going to talk about metrics, we're still in a frightening condition in this state.
Let me ask you the same question I started off with Mr. Whelan, and that is, you know, you've got a separate case. I consolidated these cases about as soon as they were assigned to me. In your case, what are you going to be asking me to do?
Your Honor, it's somewhat narrow. There are a couple different ways that this, Your Honor, could decide the case. Of course, I think we've established that the order is arbitrary and capricious. The order is heavily anchored on a safety component that proved to be a completely false promise. There is no safety component.
So you're going to be asking me to strike down the order?
That's one of the possibilities, Judge. But there is there are several principles of constitutional analysis that may be more appropriate. One of them, Judge, is that orders can be construed where possible to conform to constitutional requirements. And in this case, that would mean a safety requirement, which is not in the order. The other principle is a principle of severability, Your Honor. And what this means is courts do, and as Florida courts acknowledge, we've got cases we can cite for that, but I'll describe the principle briefly in quoting from Schmidt versus State. When a part of a statute is declared unconstitutional, the remainder of the act shall be permitted to stand, provided that, and there are several criteria, but provided that the unconstitutional provisions can be separated from the remaining valid provisions. We think that can be done here. And while the state is, of course, saying they're doing everybody a giant favor by providing for the opportunity to get a more full funding, the truth is that that was readily accomplished in March. And we pointed out that in the March order, Section 3, it deals with the funding and compensation issue in very simple terms. This is not the giant lift that the state suggests it should be. And because we know the money's already funded, it's already basically set up to be allocated. What the state has been doing is saying, you school districts, you open brick and mortar, do it our way, or we're going to hold your funding back. So what I would say, the severability component could actually be relatively finite. And if I may, Your Honor, and I won't claim authorship of this, my colleague Ron Meyer summarized some of these components, but the way we would describe the issues is as follows. School districts are entitled to full FTE from now until the October survey. That's not a long time from now, Judge, yet these coming weeks could be critical as we watch the COVID rates fluctuate. Children are well above 10% positivity in the state of Florida. And it goes on to say that it will serve the public interest by permitting local school districts to make safety determinations without financial penalty. At the end of all this, that's what we're really asking. It's nothing asking Your Honor to take this over. It's not saying that there's got to be a judicial intervention. And actually, the specific language that we would suggest would give the order constitutional vitality is school districts and charter school governing boards will receive reporting flexibility that is designed to provide financial continuity for the 2020 fall semester. It takes out the critical language and the constitutionally flawed language with an approved reopening plan, because those words, and obviously this will be in what we submit to the court, because those words have been the linchpin for what we describe and I think have demonstrated to be a financial bullying that is untethered to any meaningful safety criteria. So that is what we believe would address the constitutional issues in this case. And the record before Your Honor overwhelmingly establishes constitutional violations. I told you at the beginning of this case, and maybe it seemed like it had to be some implausible stretch, that the terms of the order, which refer to advice and orders of the Florida Health Department, local departments, I said that was pure mythology. It was non-existent. It was a false promise. And that might have seemed at the time like something of an extravagant premise for plaintiff's counsel to be using. And yet that's exactly what we've seen. We've seen it within the Department of Health's own documentation, where they say they're not going to be making determinations or recommendations about school reopening. I think we heard it from Mr. Oliva. He looked sort of puzzled when I asked him about it and said, those, whatever, recommendations, advices, we haven't heard any of it, have we? And he sort of acknowledged that, no, they hadn't. And Judge, what about, you remember those school board meetings? You saw the video clips, and you could see school board district members almost pleading with health officials. The school board district members, They're dealing with the parents and the teachers. They are right there in the midst of that community. And they were being asked to make one of the most painful and difficult decisions of their lifetimes, as all of us are, as we face a pandemic that is the worst experience in America in my lifetime. And they were almost begging the health officials, give me an answer. What is safe? Do we reopen or don't we? I remember Dr. Pino in Orange County, he looked very frustrated, like somebody had silenced him. And that's my interpretation, maybe it wasn't. But we know one thing. The safety component, the safety advice, the safety recommendation that was essential to the constitutionality of this order was evaporated, disintegrated, whether it was by some edict from Tallahassee or some confusion. We know one thing. The Department of Health's own documents showed that they were telling their health officials not to do it. So now when we go back to the order, and Your Honor asked a very good question about the language, absent these directives, the day-to-day decision to open or close a school must rest locally with the board or executive. I read that sentence and I thought, this state is going to be okay because they're entrusting this to the local school boards, which is, again, all we are ultimately, in a sense, asking this court to do. But as we also know, they've got other language in there. So my answer to the court would be the language is confusing and inconsistent, both in its face, but most especially as applied. We then go to paragraph B, which basically says, if parents want to come back to brick and mortar, you've got to do it. No matter what you think is safety, you've got to do it. So this order, I think, could be construed to say that the sentence, absent these directives, that the prerogative remains with the school boards and the superintendent, and that they shall be able to exercise that prerogative without risk of losing, in the case of Hillsborough, $200 million, in the case of Orange, $80 million. But we also think that an equally or perhaps even better constitutional result would be to sever out the constitutionally offensive language. And I, Judge, you've heard from our side, you've heard from everybody, the utmost respect for parents, the utmost concern for children with special needs. But those concerns certainly can also be better addressed. You maybe recall that Hillsborough had proposed to accelerate the timetable for special needs children. They wanted to move the brick and mortar for everybody else 3 or 4 weeks later, or 3 or 4 weeks after opening, I think to mid-September. But the state would have none of it. They are clearly insisting that massive student population return to the school. In fact, we've heard insistences that it's going to be 80% of the students in Florida. Judge, we can easily understand if the Department of Education had said, provide some flexibility for special needs children to get back earlier. But that's not what they said. And let's not let that be an excuse to validate the overall failure to address safety. And by the way, I think we can envision that if you were just bringing students with special needs into the public schools, small number of kids, small number of teachers, the task of safety would be so much more manageable. Instead, what we're going to have is pouring kids into, we've all been in public schools. I know the doctor from Stanford's never been to a Florida school, but we've all seen what they like. A lot of old buildings, some places, kind of crowded hallways, narrow doorways. We heard Dr. Nielsen talk about the bathrooms. I won't talk about that now, but Judge, these schools pouring these kids into them is throwing and packing our most precious human value, our children, packing them into a disease factory.
Let's go back to that language that says the day-to-day decision to open or close a school must always rest locally. Didn't Commissioner Corcoran, in his letter to the Hillsborough County School Superintendent, say that if you're going to close all these schools, just let me know school by school and grade by grade why you're doing it, and we'll take a look at it?
Well, his letter basically said you're not getting the funding, even though you had 5 medical professionals advise you, which if you listen to Mr. Oliva is exactly what they're supposed to do, get the medical advice. And Commissioner Corcoran said, yeah, you got to go school by school, grade by grade, classroom by classroom. How many, what are there, a couple hundred schools in Hillsborough, Judge? School by school. So that is on its face exactly the kind of burden that wasn't applied to any other big city district, which is a massive amount of unmanageable paperwork. And he didn't say that would be good enough. I think that is exactly what violates due process and burdens a constitutional right. When a bureaucracy tells you to go back, collect hundreds and hundreds of pages of information, it's going to take many, many hours to do, and then I'll think about what I'm going to do with the judge. No one else was hit with that. Not Miami, not Broward, not Orange. Clearly, that's exactly the kind of arbitrariness, effectively punishing Hillsborough, that the Constitution of Florida and the United States forbids. And it flies in the face over and over of their mantras that it's a locally driven decision. In Defendant's Exhibit 2, paragraph 36, page 36, it talks about K through 12, college campuses, child care programs are inherently high contact settings, not built conveniently for social distancing. So are we going to rebuild those buildings? Are we going to revise those buildings? Can't possibly do it. The only thing we can do, and of course, reopening will be locally driven. The next page, reopening is a locally driven decision. They turned that on their heads, Judge, after presenting their own criteria. It's locally driven without any component of safety. Judge, I don't believe this was about 2 different doctors disagreeing. I think it's pretty clear that Dr. Burke was relying on the overwhelming reality of today's science and information. What are we going to rely on? Some study from Iceland, which has, I don't know, 250,000 people population. Who knows if the virus there is mutated differently than virus here? Are we going to rely on not only our own common sense, but our most recent data, including CDC data, that says, yeah, kids transmit the virus. And in fact, if kids today, as we're sitting in this courtroom, which is not accessible to juries, as we know, it's about 14%. Well, the kids got it from somewhere. Kids can transmit. They carry viral loads. Even Dr. Hopes, with all his various statements, said that there was about a 1 to 4 contact reality. One person coming from the community of students and teachers into the community. That's the kind of spread you're talking about. So of course kids can transmit. And of course positivity is the metric and the only metric that or the best metric we have. In fact, Judge, if you review, I think it's Plaintiff 62, which is the DOH compilation of documents, you'll see they're continually referring to positivity rates. I know that the Stanford guy thinks that should be ignored and that there are no criteria that he identified that are meaningful. But isn't that exactly what arbitrary and capricious means when you have no standards? And Florida recognizes that standardless administrative agency decisions are unconstitutional decisions. There was no real answer when we confronted several witnesses. Okay, you don't think the World Health Organization is good enough, which, by the way, of course, Governor DeSantis relied upon in his original emergency order. But if the pediatricians of Florida who deal with our kids, who treat our kids, who I would think have the best feeling in the community about our kids, they're saying, please go with this 5% standard because that's the best we've got. Then I would suggest to this court that jumping into the cosmos, wondering what might be the standards is not only unnecessary, and I think that's essentially what the state has done, but it is arbitrary and capricious. Florida guarantees a safe and secure education. You cannot fulfill that obligation by burdening school departments when they get exactly the best medical advice they can, decide that they really need to put off reopening for 3 or 4 weeks, even accelerating maybe the arrival time for special needs case children. That's not good enough. And when looking out for kids and getting the best medical advice about reopening and exposing kids during the darkest hours of a pandemic, when that's not good enough, then that's government action is unconstitutional. Thank you, Your Honor. I'll reserve the balance of my time for rebuttal.
Mr. Wells.
Thank you, Your Honor. The time moving so quickly, and I want to thank the lawyers on the other side for the professional manner in which they move this forward. I feel the pain in hearing the discussion by all counsel about how tremendous a decision this is. I know that I've not slept thinking about, do I have the wisdom to make the right arguments here? What we have is a statewide association of teachers unions. Excuse me, I got to move one thing so I can see what I'm doing here. Thank you. So much for my start. A statewide association of teachers unions, and I believe 6 teachers who made it really clear they're asking the court to invalidate the decisions of roughly 1.6 million, the parents of 1.6 million children who've chosen in-person instruction. The 66 local school boards that have submitted reopening plans and are going forward with them today. The 28 districts that have opened with the remainder to follow next week. The decision of the commissioner of the State Board of Education in issuing this emergency order and approving more than 60 plans, and the decision of our governor who in this emergency determined that providing the ability to reopen schools should be a priority. And Your Honor asked the question I've been asking over and over again is exactly what is the relief that's being asked for, because it certainly started out with the relief being asked, enjoin the opening of the schools and don't allow them to open unless you say so. That's modified now, and we'll come back and talk about that more in the argument, and Mr. Hill will speak to it. But they've effectively asked the court to come in and take on the role now of the commissioner and write a new emergency order, whether it be the severing or the rewriting that Mr. Coffey talked about, but to write a new order, the order that the union would have be written by the commissioner of education. And any way you look at it, at the end of the day, what we're talking about is doing everything that can be done to stop the opening of the schools and create a disruption most amazing. They want you to enjoin the governor and the commissioner of education from carrying out their constitutional duty. It's a duty to provide education that is safe and a high quality for all. And safe does not only include making sure that the policymakers have listened to medical evidence and understood what dangers there may be in going back to school, whether it be for the students, the staff, or the teachers, but what are the dangers of not going back to school? I think you can ask any treating doctor if they had their druthers, would it be better to keep everybody home now? And they would say, yes, 5% or not, keep them home. The policymakers have to look at more than that. the World Health Organization in their papers say that this is information for the policymakers, and we know they have to take into consideration other factors like what happens when children have to learn from home and are impacted by virtual education, are impacted by being in abusive homes, impacted by being in homes where there is no internet, impacted in being in homes where they don't have the nutrition that they need. Those are the obligations that our elected officials have and have tried to carry out here. There's another obligation that's wholesale being ignored, and that's the obligation to supervise the individual school districts. Mr. Hill will walk through those constitutional and statutory provisions, but it's very clear that the role of the Department of Education is not to make suggestions and then to allow the school districts to do it however they feel, whichever way they feel, without regard to what it ultimately looks like. Ultimately, you're being asked to write out the plain provisions of the Constitution as obligations placed upon the commissioner and the governor, and to ignore the clear directive of the First District Court of Appeals in terms of their obligation to supervise. One thing that struck me as the relief has shifted and moved here is now the teachers union wants to stand up and wear the hat and clothes and shoes of the 67 school districts and argue that this is a bad order because it is coercing us school district. It's caused us to do plans that we would never have done otherwise. Yet there's no school district represented here. There's no lawyer standing up and talking on behalf of any school district to say that we've been coerced, we've been told to do something that we shouldn't do. Yet, what they're asking to do is to flip the switch on the reopening plans amid the opening, to assume that the 400 some odd elected board members and the 67 school superintendents have shirked their duty. They bowed to the governor, they bowed to the commissioner, and it's not fair to paint them that way. Not fair when they're not here to represent themselves. Not fair with the only voice is one board member from Hillsborough County who did not like the fact that her county voted to open. And that is a view that properly held, understood, but it doesn't mean that the governor and the commissioner of education have somehow come in and forced safety to the background and to let havoc be wreaked on everyone.
Well, under the emergency order, what choice did the districts have but to submit a plan in accordance with the emergency order?
Absolutely none. They do have to. Well, I take that back. That's not true, Your Honor. It's very clear, I believe, on page 6, that you don't have to submit one of these plans. Right,
but you lose a lot of funding if you don't do that, right?
There's no question about that. I'm not going to dance around that. That's absolutely right. But if you can pull that up for a moment, Mr. Hill, let's just go ahead and pull up the first part of Emergency Order 6, because I think a lot's happening here that doesn't involve really looking at the clear language and how it works. So,
well, let me finish up with that question.
Yes.
So the Commissioner Corcoran enters this emergency order July the 6th, I think. And it says, upon reopening in August, all school boards and charter school governing boards must open brick and mortar schools at least 5 days a week for all students. So that the school district didn't have a choice but to open, right?
let me answer the question that way. I mean, answer the question this way. They had to open brick and mortar schools at least 5 days per week. Looking at the very first sentence there, go to the next page, Nate. So let's look at that. So they do have to open brick and mortar schools at least 5 days a week per week for all students, subject to, do we come up with a new advice or order from the Florida Department of Health? Does the Florida Department of Health come out and say, no, not do it? Does the local Department of Health or Executive Order 2149, which I actually think say typo because it's 2139 that provides for the emergency relief and subsequent executive orders. So it's saying, as of now, as of this order, yes, you have to open brick and mortar schools, but you have to read the next sentence. You have to read these two together. Absentee.
Well, hang on a second before we go to that, because it says you got to open them 5 days a week, subject to advice and orders of the medical people. What does that mean? I saw these school board meetings where the medical people were saying, "Hey, we don't give advice on that."
I think there's two different pieces of that, Your Honor. This is talking about subject to, are there going to be any more orders changing this? Will the Florida Department of Health or a local Department of Health, or under Executive Order 2139, which is the original one, I believe, where they closed the schools. If you get any one of those orders, that may very well change it. But if not, absent these directives, then let's go down to what the individual school districts will do. The day-to-day decision to open or close a school must always rest locally with the board or executive most closely associated with the school, the superintendent or school board in the case of a district-run school, the charter governing board in the case of a public charter school, or the private school principal, director, or governing board. So what it says is, yes, you are supposed to open these schools, but you as the local board have the power, the right to make a decision not to open a particular school because it says open, or close a particular school. And Your Honor read the letter, I think, dealing with Hillsborough County absolutely correctly. What it said was, wait a minute, you submitted a plan saying you were going to open up, I forget if it was August 21st or August 31st, you were going to open up, and now you're saying you will not open any school. You need to come back and let us know and roll up your sleeves on a school by school basis and tell us what's going on.
In a grade by grade basis is what the letter said, I think.
School by school, grade by grade. Absolutely. The department is exercising the supervision that it is supposed to do. It is exercising the supervision to say, look, if you are not going to open these schools, then show us why you need to do that. Show us that you can't open for anybody.
So if a school board or a school superintendent said, hey, Governor DeSantis, Commissioner Corcoran, we've got a positivity rate in our county of 15%. We just don't think it's safe to open our schools in this county. That the commissioner could come back and say, hey, look at the 240 schools in your county and go by school and grade by grade why that particular school or grade may not be able to open. Is that what that means?
I think it does, Your Honor. And I think we'll go back to some of Mr. Coffey's questioning about the fact that the impact of this virus is different from neighborhood to neighborhood. It's different from school to school. And while you can say that at some percentage, it would make no sense to put, I'll pick the school I went to, Miami-Norland. When I went there, it had roughly 3,500 people in there. And I could see sign, it was crowded as could be. Makes absolutely no sense to open that school to all students at that time. But it's a monster campus, goes on for acres, several buildings. Is it subject to being opened to half the students, to a third of the students, to only particular students? That's the discipline that's being asked for here. And I think it's telling that they didn't come back without analysis. Instead, they said they're going to go forward and open. No one here from Hillsborough is saying that we went ahead and opened this even though we think we shouldn't do that. We heard one school board member's view on that, but Hillsborough has got a superintendent. They have a legal staff. If they believed that they were being forced into doing something they should, they're the ones that should be being here. They're the ones that should be talking to this court about it, and not the teachers union trying to lever that as a basis to strike this down. The district.
What about teachers now? We've with the students going back, I think everybody that testified said that kids need to be back in school, and that's better for them from their education and socialization and all that goes with going back to school, and that there were lots of parents that want their children back in school. And we've got teachers now, and I think I heard the governor and the commissioner say that if a teacher doesn't feel comfortable going back, then they should be accommodated. But that's obviously not happening according to the testimony. What about that?
Your Honor, I think that the testimony is certainly clear that with some of those teachers, they have not been able to work out an accommodation. Let's talk about for a moment what the emergency order does and doesn't do in that regard. It does provide funding that they would not have available before. The genesis of the executive order was the superintendent of schools in Miami, who knew there was going to be a large number of parents say, we want to do e-learning, was concerned that because it's funded less, he'd have less money. He'd have to lay off teachers and they'd be gone. That money was provided to stop that. But in addition to that, there's $700 million been provided through Florida taking its CARES money and allocating $700 million to education to try to allow those accommodations on a school district by school district basis. They may very well not have ultimately the ability to accommodate every teacher who, for medical reasons, should not come back.
So what happens to that teacher then?
I think that that teacher can take medical leave under the Florida Medical Leave Act.
Unpaid medical leave, right?
I don't think there's any question, Your Honor. They end up in the same position that so many Floridians have been in, where because of their personal health reasons, it's just not safe for them to be out and about. And they've not been able to do a job. That's why the workers' compensation, additional compensation was paid out for folks. I think the hard truth is that if there's going to be a public policy decision, the schools are going to open, there are going to be some teachers, not just teachers, people that work as custodians, people who work in the cafeteria who may well not be able to go back. Now, I think if we look at the science and what we were talking about and look at the particular teachers that were here, that even if it was at 5%, those same doctors would be telling those same teachers, you should not be going back to school. You should be trying to teach virtually. They'd be in the same position, those with the compromised health, where you're talking 5%. Until you have a vaccine, until that's eliminated, there are going to be people who have risk. There are people that are working in grocery stores, filling stations, hospitals, everywhere, Your Honor, that you have to deal with those same choices. I don't think that that's something that can be rectified by trying to write out the emergency order. I mean, the plaintiffs are saying, let's just let it go back to the superintendents who, as I said, aren't here. What's going to happen when those superintendents say, no, that we're going to open? They've already said that. We've got this assumption being made without any proof by the plaintiffs that the only reason that they've done that is because the heavy arm of the government has forced them to do that. But what's the next fight? Let's not fool anybody here. Teachers unions already brought a lawsuit in Orange County seeking to enjoin everything pending their arbitration. They stopped the injunction point because they've got this hearing in front of you. But the next fight here is going to be with the school boards and superintendents saying, wait a minute, you're going to open up and you're going to have students in the classroom, and you're going to make some of our teachers come in. It's just a fight delayed. It is not a fight corrected by this case. And I think importantly, Your Honor, if that's where the fight's going to be, superintendents should be the ones being here. The superintendents and the school districts should be the ones saying, Judge Dotson, we feel like we've been coerced. Judge Dotson, we don't think that this is the right way to work. Judge Dotson, those 66 plans that are out there, 60 of which have been approved, we really didn't mean it. And we would do something wholly different at this point in time. None of them are here. No proof has been put on that that's what they would do. The union is trying to use them as a stalking horse for their issues with standing and their problem with the fact that this, at the end of the day, is ultimately a policy question. Yeah,
to what extent does medical or scientific information play a part in Executive Order 6?
I think what it expects and what it anticipates is that the school districts will make their decisions based in part on the medical information that's out there. But it is, at the end of the day, Your Honor, a policy.
I have trouble making that leap, though, because it says you got to open.
But then the very next sentence, Your Honor, Absent these directives, the day-to-day decision, whether you go ahead and open a particular school or close a particular school, must also rest with them locally. And we would expect what we saw with Dr. Hopes, that there was a detailed analysis that they did, reaching out to the resources. You heard him walk through the resources that were made available, not just him sitting there as an epidemiologist, the Department of Health making nurses available, taking advantages of the resources out there to come to a conclusion on what ultimately makes sense and then go forward. Plaintiffs suggest that all of those decisions are all fake. None of them were made conscientiously by these school boards, hearing the medical evidence on the one side, hearing from folks saying, here's the risk if you go back to school, but also considering the risk if you don't go back to school. And that's where it plays in anybody's decision. Shall I go on?
Yes, sir. Yes, sir, please. Yep.
All right, let me see if I can slide back to where it makes sense. Let's talk a little bit about the medical evidence that's been put on here. I think what the medical evidence demonstrates, Your Honor, is just what's going on. Is there a difficult policy decision that has to be made? If you look at, let's find my spot here. Let me, before I get there, let's talk about the medical evidence. What the plaintiff said, there should be a bright litmus line here that the World Health Organization has made it very clear, and the CDC has made it very clear that unless there's less than a 5% positivity rate, that no school could be open. It's simply not there. There's detailed guidance from the CDC on how to open. We have provided that to Your Honor. There's no reference anywhere to a 5% standard. The plaintiff's answer to that is Mr. Redford's answer to an interview question, which is found at Plaintiff's Exhibit 7. And I invite the court in its time before making a decision to read that and think about if it's really there. And then ask the question, if the CDC has given page after page of written materials, including what they've laid out in Exhibit 5, the important, Defendants 5, the importance of reopening America's school this fall, and the importance of reopening schools. If they've laid all this out, if the folks from the same Harvard school that Mr. Burke was at in Exhibit 4 have laid all of this out, then why would they not have in there this 5% litmus test? It's not. And even if you look at what the World Health Organization says in the document that was referenced in the cross-examination of Dr. Bhattacharya, it's interesting. First, it doesn't deal with the opening of the schools, but even in that exhibit, which I believe was their Exhibit 7, it says you look to see if less than 5% of the samples are positive, assuming surveillance for suspected cases is comprehensive, pointing out exactly the problem that Dr. Bhattacharya was talking about in terms of non-random sampling and bias sampling. But they go on.
That World Health Organization report done May 12, 2020, I read that as applying to schools. The first sentence says, in response to COVID-19, countries around the globe have implemented several public health and social measures, including large-scale measures such as movement restrictions, closure of schools and businesses, geographical area quarantine, and international travel restrictions. And then it comes down at the bottom of that page, and under Table 1 of epidemiological criteria, says you need less than 5% of samples positive for COVID-19, at least for the last 2 weeks, assuming that surveillance for suspected cases is comprehensive. And that seems to be dealing with many things, including opening schools, the way I read it.
Well, it talks about opening the state, which certainly would include schools. I think if you go down to the next sentence, it points out this document presents only public health criteria, while other critical factors such as economic factors, human rights,
Right.
food security, and public sentiment should be considered, which is my point, is that 5% is not a litmus test that they've provided to say thou shalt not go forward. They make it very clear that there is a policy decision that you have to look at and say, okay, the risks I have if I move forward are X. The risks I have if I don't open school are Y. And how do I make the balance? And if you can pull up Exhibit 5 for a second, Mr. Hill, the CDC goes to great effort to lay out the other side of that equation in the document, the importance of reopening America's schools this fall. And as it starts out, and you can put that down, the judge can find it. It says, as families and policy makers make decisions about their children returning to school, it's important to consider the full spectrum of benefits and risks of both in-person and virtual options.
I think everybody that testified in this case and every lawyer involved in this case has been very sincere in trying to strike that balance too, but it's hard. You read the CDC report and it comes down in the bottom of the page and says, international studies that have assessed how readily COVID-19 spreads in schools also reveal low rates of transmission. So that sounds great. But then it says when community transmission is low, which is again saying if you've got a pretty high community transmission rate, then perhaps COVID-19 spreads much faster in schools, is the way I read that. The CDC report was very well written and explaining the danger of COVID-19 transmission and weighing that against the importance of and the full spectrum of benefits of in-person learning options. And I guess that's what, are you saying that we just in emergency order 6, that's a weighing test, and the weight of having kids back in person in school outweighs the safety risk?
I'm saying that is the balance to be weighed, Your Honor. And I think reading this particular report is particularly pertinent. There's a whole discussion on the impact of children, and much of it supports exactly what Dr. Bhattacharya says. But I think what it tells us is that it is a policy decision. There's not a bright line to be had there. And as we're navigating forward and these plans are going forward, number one, we can see great variety in the plans. We can see great variety in how many parents have their children going to school, and accordingly, how many teachers are going on a district by district basis. We see how in South Florida, in Dade and Broward and Palm Beach counties, those plans take that into consideration. They're not even opening in person until at the earliest October 4th. The school boards have certainly taken that into consideration case by case. We talked about Hillsborough. Monroe County is very much the same. They made a decision that they needed to make a modification and go forward. They've looked at that. They since revisited it because their belief was that the lobster season would be a problem, and it turned out not to be as bad as they thought. But they are, exercising that type of deliberation, that type of decision making, and there's been no proof here other than the limited testimony of Ms. Schomburg that would suggest that any of this policy making decision that happens at the school board level hasn't been thought out by them properly, and they're not moving forward properly. If that's going to be the case, it's a very different case than we have here. There's an argument that, my goodness, the Department of Health local representative would not tell Ms. Schomburger whether to open or not. I think that the representative of the Department of Health made very clear why that's the case. Their job is to provide the data and the information. They don't tell the policymaker whether to open or not. They're not the one that looks and says, okay, across my campus with these people, with these needs, that I'm going to do it based on any particular percentage. They give the information to the policymaker, and just as it's suggested in this article, and just as your honor just talked about, they then make the decision, weighing on the one hand what needs they have to get their children back in school, how many of those, if there are particular ones that are important to get back in school, and do that. And these plans have been flexible. We put the 67 plans in, and while they all call for bricks and mortar, they're being occupied at different rates and with different plans. If the superintendents and the school boards of those schools come to the conclusion that no, they're being required to put their children in harm's way, they have a voice with the Department of Education, and they certainly have a voice with the court. The superintendents have not been shy in the past when there have been issues and arguments with the Department of Education to bring those claims. They're not here. And these plaintiffs, these teacher unions, aren't in the position to come in and say that the policymakers in these 66 different districts have done something wrong, and therefore your honor should go ahead and rewrite this order and throw it out because they think it could be a problem. It isn't, and they have not proven that. Honor, let me just wrap up and turn it over to, unless you have more questions for me.
I don't think so. Not at this time. No, sir.
Well, let me just wrap up then and say this, that 66 districts have made these policy decisions. Their plans have been approved. The schools have reopened and the remainder are reopening. Plaintiffs have made it clear that their goal is to have no school open and to turn the status quo on its head, current education on its head. It's a critical impact on 1.6 million students across 67 districts. Those parents and those students have no union. They have no voice except through the Department of Education. Their voices have been heard in the declarations and the testimony from Ms. Tribble and Ms. Pope. Those parents have no union lawyers and experts to represent them. If the governor and the Department of Education are neutered and left helpless to carry out their constitutional obligations, then the unions will have their way. The schools will not open. Now, I'll turn it over to Mr. Hill to talk about the law.
Mr. Hill.
Thank you, Your Honor. I will try to be brief. I know that we've submitted several papers addressing these legal issues. We've got a motion to dismiss, a reply to that motion to dismiss. And we also filed a substantive paper responding to the motion that we're here on today, which is a motion for emergency relief, temporary injunction to enjoin all schools from opening in the state. I want to emphasize the extraordinary high burden that the plaintiffs have to meet to get this request. There is really no higher burden in the civil system than what they are asking for today. And the reason for that is obviously clear. What the court has is 2 days of mostly anecdotal evidence on their part to decide whether or not to send millions of children home who have chosen to go to school. It's a very momentous decision that the court has to make with very limited evidence. And
is that really what they're asking me to do? What I heard they were asking me to do was to strike down the order and turn the decision over to the local school boards.
Well, that is what the Miami plaintiffs asked. The Orange County plaintiffs, I believe, asked for the court to enjoin the defendants from opening schools based on an arbitrary order that's arbitrary under Florida statutes 1006.07.
Well, I wrote down what Mr. Whelan said, and what I wrote down was strike down the order and it reverts to a local school board decision.
I heard him say both, Your Honor, but I can address both. I can address the latter for you. So the point about school boards, let me start first with going through exactly what authority the state defendants have in this case. So this is Article 9 of the Florida Constitution. This is what this entire case is about. This is where the constitutional injuries they claim to have suffered arise from. It provides, it is the paramount duty of the state to make adequate provision for the education of all children residing in its borders for a uniform, efficient, safe, secure, and high quality system of free public schools. Section 2 of Article 9 talks about the authority of the State Board of Education to supervise. It provides, the State Board of Education shall have such supervision of the system of free public education as is provided by law. Section 4 of Article 9 deals with the authority of the local school boards, and it provides, the school board shall operate, control, and supervise all free public schools. Now, there's clearly some overlap there because both talk about supervision. But thankfully, we have a separate statute that helps explain what that means. Section 1000.03 of Florida statutes. That said, with respect to the State Board of Education, it shall oversee the enforcement of all laws and rules and the timely provision of direction, resources, assistance, intervention when needed, and this is important, and strong incentives and disincentives to force accountability for results. This is exactly what the emergency order is designed to do, to both incentivize districts to meet the constitutional obligation of the state defendants to provide not only for safe and secure schools, but for a high quality and uniform education that is within the constitutional direction for state defendants and fully consistent with the law. Now, I'll keep walking through because it has a few more interesting points. It explains that public education is a cooperative function between the state and local authorities. The state retains responsibility for establishing a system of public education through laws, standards, and rules to assure efficient operation and adequate educational opportunities for all individuals. Local authorities have a duty to fully and faithfully comply with state laws, standards, and rules. Now, there's also a case that sort of describes what can sometimes be seen as a bit of a conflicting obligations. And I cite at the top, and we cite it in our paper, Your Honor. And it said, the Florida Constitution creates a hierarchy under which a school board has local control, but the state board supervises the system as a whole. The broader supervisory authority may at times infringe on a school board's local powers, but such infringement is expressly contemplated and in fact encouraged by the very nature of supervision by the Florida Constitution. Your Honor, that is exactly what the emergency order is designed to do in this case, to encourage the state or the local boards to provide not only for safe education, but for a uniform and high quality education.
How does the emergency order provide for a safe education?
So, Your Honor, what the emergency order does is it balances these competing constitutional obligations. Because in this particular situation, you have the pandemic, which creates an unsafe situation really everywhere in society, and certainly schools are not preserved from that. But the state defendants cannot focus only on a safe education. They also have to provide a high quality education. And the way they've chosen to do that is to allow parents and children to choose whether to come into school or whether to learn from home. It's a tough balance. And no matter what, somebody, as Mr. Wells said, one person on this or one group on either side of this is going to be harmed. You can't both give children a choice or parents a choice and teachers a choice. Somebody loses in that situation. If we base our policy decision on whether teachers want to come back, then as a necessary corollary, some students won't be allowed that opportunity to come to school. What the state defendants have chosen to do is to balance this in a way that provides for a safe and a high quality education for students and allow the students to choose whether they want to come in or whether they want to stay home. And that the necessary implication of that is that if a lot of students choose to come back, there will be some teachers that will be asked to return in order to accommodate those in-person students. And so that's what that's the argument of the state defendants in this case, Your Honor, is that this is a tough balance. But we are required to balance not only safety, but everything. And this is a reasonable way that we've decided to do it. And I'll address a few of the other issues that defendants or that the plaintiffs raised at the beginning, but I just want to walk through a couple other issues. And the first is that it's important to remember that we are in a courtroom. We are not on the floor of the legislature. We are not at a school board meeting. They must have an injury, and they must tie that injury to an act of the defendant. And the injury must actually be redressable by the court. So let's walk through what they've said and what injuries they have. First, as Mr. Wells noted, there are no school boards here. To the extent they claim that the emergency order unfairly coerces school boards, first of all, we've addressed this issue in our papers. But the problem with that is that this person, the entity with the standing to challenge that are the school boards themselves. And I can cite a case right here for Your Honor that talks about the school board standing to challenge these sorts of funding rules. And that's School Board of Collier County versus Florida Department of Education. And that's at 279 Southern 3rd, 281. The problem is, and we cited this in our papers, Lujan versus Defenders of Wildlife, the United States Supreme Court case, explained the problem with these sorts of cases. And it said, when the plaintiff is not himself the object of the government action or inaction he challenges, standing is not precluded, but it is ordinarily substantially more difficult to establish. And it went on to explain that standing cannot be established where one or more elements depend on the unfettered choices made by independent actors, not before the courts, and whose exercise of broad and legitimate discretion the courts cannot presume to either control or predict. This case is the perfect example of that problem. The facts here are this. If the court were to grant the relief the plaintiffs are asking and provide that the state defendants cannot force schools to open, there is no evidence before the court right now, and certainly no plaintiffs before the court right now, to show that the schools will actually close and that no teachers will still be asked to return. And that is what the injury is here, Your Honor. The injury here is teachers being asked to return to school. And they must connect that injury to the complained of act of the defendant. And they cannot do that, or they have not done that here, because there's nobody to tell you that the school boards will in fact keep those schools closed and prevent that injury from accruing to the teachers. So what we're really talking about in this case, and I think they've dropped a lot of the claims that this is really about children, because there are no children or parents before this court who are being forced to go back to school. As I said beginning, and as Mr. Wells said, the state defendants have chosen to give those choices to parents and students. In fact, the only evidence the court really has is a declaration from Plaintiff Bellafleur, who says at, I believe, paragraph 11 of her declaration that, and I quote, "I am able to currently keep my children at home to attend school virtually." Her problem is that she wants more guidance on how the schools will keep her children safe. So there's no legally cognizable injury here, at least they have presented none. So what we really are left with is we are left with teachers, and they break down into a few categories. First, there's a subset of teachers who want to go back to school in person. And we know there's thousands of teachers that have chosen to return. Second, we have another subset of teachers who will choose not to return, but who will be permitted to teach virtually. Third, there's a subset of teachers who will ask to not return, but who will ask for accommodations somehow and will be accommodated. There are clearly accommodations that can be made, and Dr. Hopes testified yesterday that they have made accommodations to teachers when requested. So the final subset, and this is what we're really here about, is a group of teachers who want to stay home, but for whatever reason, an accommodation cannot be made for them to do it. And that is because too many children chose to come back. And so you either have to tell those children to go home or find teachers to teach them. And so what those teachers, what that subset is asked to do is to make a horribly difficult choice, Your Honor. And that is to return to school and face an increased risk of contracting a disease, or to take to either stay home, to use sick leave, to use FMLA leave, to take a leave of absence, to quit, or to retire. Now, those are two horrible choices, Your Honor, but you cannot conflate that choice with teachers being forced to return. The plaintiffs cannot base their requested relief here on presuming teachers will choose the more harmful of those two options. So what the court has to presume for purposes of this motion is that teachers will choose to quit or to leave, as opposed to returning to school and being subjected to the disease. And as horrible as that choice is, there is an adequate remedy at law for that. And that is through the grievance procedure, which everybody agrees exists here. It's not perfect, and it's certainly not what any teacher wants, but it is nevertheless an adequate remedy at law. Now, one plaintiff, and forgive me if I forget which counsel made this argument, but they talked about how horrible the decision is, that teachers who have made this their life's work, this is their passion. We fully appreciate the gravity of this problem, but leaving your chosen field of education is not an irreparable injury that this court can provide or can protect from this in an injunction that they're requesting here. They have an adequate remedy at law under their contracts, and the law does a very good job of providing for those types of claims. And the final element that the court has to consider, and I haven't addressed the substantial likelihood on the merits prong that they have the burden to fulfill here, because we've addressed that in our papers, and there are a myriad of reasons why this claim is problematic. But the final thing that they have to prove is that this injunction would be in the public interest. And most of Mr. Wells's closings talked about how that is not clear. We're not talking about whether ultimately they're entitled to their relief, whether ultimately they've stated a claim. We are talking about whether they have proven the high burden of showing that this injunction is in the public interest. And the only evidence the court has before it is that this relief, at best, harms either 1.6 million children or the 8 or 9 teacher plaintiffs that are here. Neither one of those is clearly in the public interest, and that is what the plaintiff's burden to establish, and they have provided no evidence for the court to make that difficult choice. And I want to just address briefly, Your Honor, I'm almost finished here, a couple of the arguments plaintiffs made in their closing. Now, first, I'd point out that we've seen virtually no substantive legal argument from either side. We have one response to our motion to dismiss. So in part, we're left, in essence, punching in the dark because we don't know exactly what they're seeking. And in fact, when they began their closings and the court asked them to tell you what it is they want you to do, that was the first time we've heard clearly what it is that they want in this case. So our hands are tied a little bit in trying to address all of these complex problems. But I'll just address what they brought up first. One is this notion that the order is arbitrary and capricious. Well, we cited some cases in our response to the temporary injunction. The standard in this case is set forth in Citizens for Strong Schools, and that's at 232 Southern 3rd, 1163. And it provides that in this situation, plaintiffs have to prove beyond a reasonable doubt that the state's education policies were not rationally related to the provision by law for a uniform, efficient, safe, secure, and high-quality system of free public schools that allows students to obtain a high-quality education. That is an extraordinarily high constitutional burden. And when you pile that on top of the extraordinarily high burden for this particular relief they're seeking, they simply cannot meet that burden, and they have not on the facts in this case, Your Honor. In part because the rational decision that was made was to balance safety and high quality by allowing parents to choose. The inquiry need go no further than that. That is undoubtedly a rational choice. It is not for this court to second guess the policy decisions of the executive branch. And that is simply the end of the analysis. And I also want to address some of the issues briefly that what the plaintiffs in the Miami cases are asking for the court to do. So first they ask the court to strike it down because it's arbitrary and capricious. Again, the standard on that is rational basis. And that is very deferential in this case to the state defendants, and that precludes the relief they're seeking here. What they're really asking now, and this is the first time we've heard this one made clearly, is severability. And I'll address it as best I can, but like I said, Your Honor, we have not been able to look into this in much detail because it's the first we're really hearing about this form of relief. So what they're asking effectively for the court to do is to take the executive order, the emergency order, which does two things. it waives the Florida statutes that require funding to be based on in-person attendance. And to take that portion and leave it and remove the portion that requires schools to reopen. Now, as I went through before, I think that the statutes and the Constitution, the constitutional delegation of authority makes what the executive chose to do in Emergency Order 6 perfectly within the bounds of the law. But for the court to do what they want, what you'd have to do is effectively waive the funding statute. The only reason that the Commissioner of Education here is able to provide full funding is through the emergency authority granted by the governor. And what he does is he waives the normal requirements under Florida law to fund schools by in-person education. So for this court to do what they want, you would have to assume that authority and find that those legislative provisions are waived. They're not challenging the authority of the commissioner or the governor under their emergency powers to do it. They're not challenging the constitutionality of those legislative enactments that they're now asking the court to waive. What they want the court to do really is to write a new emergency order. And that is simply not something that the court has the power to do in this situation. And even if the court were to grant their relief and strike the emergency order, what we're left with is a situation where schools are still facing funding problems because Florida law that has nothing to do with this case and has nothing to do with the Commissioner of Education would still deny funding to schools when kids did not show up. And so to the extent that there's pressure being felt by school boards to reopen, that pressure is not going to be abated by a temporary injunction in this case. And unless the court has any questions, I have nothing further.
Let me ask you on that funding question that you just talked about. And again, let's say hypothetically that a school board decided to say we're not going to open schools until September 20th. As I understood Mr. Oliva's testimony yesterday, the FTE full-time equivalent survey is done in October. And if the kids are back in October, they would not lose any funding, right?
So my understanding of how it works is that even though the survey takes place in October, they have to budget today for what they think it's going to be. And when it comes in October, if it turns out that their funding is not at the same levels as they predicted, there's a settling up that has to occur.
But the kids are back in October, then there's no funding cut, right?
That is correct, Your Honor. If the kids come back in full under normal Florida law, funding will proceed as normal and they'll get funded as they normally would if all the students came back.
Okay.
That is correct.
All right. Thank you, sir.
Thank you, Your Honor.
Counsel for the plaintiffs, you have about 20 minutes left.
I'm muted, and let me turn to what Your Honor just addressed. We think that the funds have already been appropriated. They've already been, designated in a sense, because we know that Hillsborough was threatened with losing a $200 million amount. If an order based on your analysis of the evidence before you and the law were to be entered that basically suspended the Department of Education's, I'm going to just call it, this is our language, perhaps not yours, their threats, financial threats. We called it financial bullying until the end of September. And we look at the health realities. We look at the safety realities. Boy, a lot could be in place if a school district chose to, in effect, hold off reopening until the end of September. Because remember, we're not asking this court to shut down the Florida schools. That's not at all what we're asking for. We're saying it's in the public interest to let the local decision makers, and I think Mr. Oliva acknowledged yesterday, the school board district members, they hear from parents all the time. Mr. Wells suggested, where's the parents' voice? I assure you, and Your Honor probably knows school board members, they hear from parents all the time. The parents have a voice, and it is a much more knowledgeable voice and frankly informed voice than the threatening voice from Tallahassee. So the result would be, and Judge, obviously, these are difficult issues. We hope to put it in a comprehensible way in a proposed order. But if Your Honor were to give school boards the latitude that they need and that they deserve with these tremendously difficult issues, then that order could be put into effect until whatever, and we'll identify, but before the October count. And there is no disruption. No one's turning the Department of Education upside down, but at least there's a process for addressing safety. Judge, this order completely ignored safety. It did one thing with respect to safety, and we all agree that a safe education is a paramount duty under the Florida Constitution. And the state is suggesting, well, you know, you've got to balance all these things, but there's no safety component to even balance, because the safety element that was in this order, subject to advice and orders of the Florida Department of Health, local departments of health. We know that was pure fiction. And putting fiction or pretext or whatever we want to call it into an order on the pivotal issue of safety, yeah, that's arbitrary and capricious. And it also violates the obligation, the paramount duty with respect to safety. And so when we talk about what we think is legitimate metric, 5% or less, the other testimony that I heard doesn't say that the Department of Education has chosen a different metric or different state safety criteria. They have chosen none whatsoever if you look at this order. Now, I did hear from a professor who said, you know, let's listen to Iceland. So there's really no safety issue because it's just kids infecting kids after all. I think that testimony is utterly fallacious and at odds with the prevailing views in this country and the World Health Organization and the Florida Pediatrics. But it's also heartless to say, so what if it's just kids infecting kids? And right now kids are at a positivity of 14%. And I don't say that I have the wisdom to know how to better address that, but I think that our position is if the school districts themselves can do it without the enormous pressure of a heavy sword hanging over their head, then I think we will have somebody who will balance it. Because remember, unlike the Department of Health, the school districts were active in trying to get medical advice. We didn't hear anything from Mr. Oliva yesterday about who they consulted when this order was entered. We didn't hear anything at all about what their safety parameters were. But we know, because you saw it in this case, that the school boards were doing their very best to get it. And then I asked Mr. Oliva, because Hillsborough had five doctors who came in and were willing to be publicly accountable for their opinions that it was unsafe. And of course, the health director was not willing to be publicly accountable for whatever reasons that might have been. But the school boards are willing to and have tried to engage medical advice. They don't want kids hurt. They don't want kids sick. They don't want teachers or family members to die. But they have effectively been bludgeoned by this order. And we suggest to Your Honor that this order, within well-settled principles of severability or construal in favor of constitutionality, can re-empower the school boards to do their job free from the unconstitutional burdens of an order that marginalizes safety and is arbitrary and capricious in its foundation. And we know, Judge, that when administrative agency is reviewed, there are occasions when you defer to their expertise, but it's not expertise that's outside of their knowledge zone. So, for example, the Department of Education has no demonstrated expertise with respect to infectious diseases. None whatsoever. So there's really no judicial deference that can possibly be due. And I could cite Gonzalez versus Oregon, but a lot of cases confirm to that well-settled principle. We also know that presumably the Department of Health might have been a relevant factor. That's what this order essentially invited, but they've disappeared. Whether you call it missing in action or walking off their post in the time of duty. So what we're left with is not a balancing test that this order provides. What we're left with is an order that completely turns its back on safety. I'll cover a couple other points, Your Honor, and then we can conclude. We know that Miami-Dade and Broward and Palm Beach weren't told you have to go school by school, grade by grade. That's preposterous, obviously burdensome, and exactly the kind of punitive demand the state made when Hillsborough wasn't falling into line. And by the way, why should a kid in Tampa be funded any more for education than a kid sitting across the street from me in Coconut Grove? Part of the arbitrary and capriciousness of this is the way it potentially impacts on different kids. And why should a safety determination in one county by a local school board be marginalized? That is something that they have and cannot have any answer for. The parents have a voice. The school boards have been listening. Medical testimony, medical evidence is urgently demanded. The state has provided none. And the only source of medical advice, whether we call it advice or directives, we know what those words mean. And we know that those words have been utterly meaningless in this emergency order. So for all these reasons, Judge, we would say that the elements of an injunction have been satisfied. We're here on a temporary injunction, and we believe the court can fashion a remedy that is consistent with the principles of severability and constitutionality that courts have traditionally applied, because this case is part of the judicial process which oversees and protects the constitutional rights of Floridians. And we respectfully submit that on the evidence before you, it is clear that there is a pandemic, there is a risk, there's a COVID virus that is beyond anything we've ever seen before in this country and anything we may ever see again, and that the paramount duties of safety and rationality must be observed. Thank you, Your Honor, for your consideration.
Mr. Whelan, anything further from you with regard to a final closing?
No, Your Honor, I think Mr. Coffey did a good job summarizing what we would have had.
Well, I certainly want to commend all counsel for their professionalism and advocacy in the case. I do want proposed orders no more than 15 pages by 5 o'clock today so that I can get started on this.
Your Honor, may I be heard briefly?
Sure, Mr. Hill. Yes, sir.
There's a couple of things that they've raised today that we haven't heard before. I know Mr. Coffey has said that there's a lot of case law and severability. We're just not quite sure what that's going to be, and we would appreciate a little time to respond to that, even if it's just until noon tomorrow.
Get me your first stab at it by 5 o'clock today. And if you feel like you need to supplement that by noon tomorrow, go ahead and do that. But get me your first stab by 5 o'clock today.
Will do. Thank you, Your Honor.
All right. Court's adjourned.
Thank you, Your Honor.
Thank you, Judge.